H-O-Q. Yep.
All right, we're about to start in a couple minutes, or we're actually about to start now. If you guys could all take a seat.
Oh, actually, you don't want to use that QR code. Yeah, I should have. This is my old business card, but yeah.
If you guys could all take a seat, that would be phenomenal. Thank you. Thank you.
Leave out the end.
We're about to start in 1 minute.
They're looking at you.
Yep, that one right there. Yep. Okay, great.
Yeah, thank you.
The card. Yep, great. Okay, thank you, Scar.
Thank you. Thank you. Thank you. Oh, okay. Well, thanks. Okay, cool. Well, now that everyone's sat down, we'd like to start the session. First of all, thank you all so much for coming today. My name is Tom Nakata, and I'm the co-founder and CEO of Qlay, Qlay, and we're the host of the session today. As our guest today, we have Stephen Ho from American Patent Agency come present us the artificial intelligence as inventors, the complicated status of patent in the age of AI. But right before we get into the content, we would like to do a little bit of a self-introduction. So we're called Qlay, we're the host of today, and we're essentially a startup based in San Francisco, and we're an AI recruiting startup. Quick introduction about myself. Previously, before founding this startup, I worked at McKinsey. I did a lot of organizational strategy, and my co-founder, who's doing the live stream back there, is also a serial entrepreneur as well. And we help other startups hire and pay vetted, mostly global engineers. For a lot of startups, finding an engineer is difficult in this day and age. A lot of companies use platforms like Fiverr and Upwork, but you still have to talk to every one of them and screen them and make them do coding tests, and it tends to be a lot of work. So what we do is we essentially replace that processes with AI interviews and AI screening and AI coding tests. We're able to realize a lot shorter hiring cycles for startups who are busy, and we're also able to cut a lot of hiring costs that stack up for a lot of startups. When startups try to hire real employees, they have to deal with benefits and stock options and things like that. We take the complication away from hiring, and we do a lot of simpler global cross-border hiring. Right now, we're doing around 70% month-over-month growth. We do target mostly startups, but we have been working a little bit with public companies as well these days. We do a lot of events. So today we're in Palo Alto, but we do a lot of events mostly in San Francisco. In May 19th, we're hosting a pitch night in San Francisco with many VCs as well as accelerators. And on May 28th, we're hosting another event, panel discussion with president and co-founder of Ncord, another YC company from a couple of years ago, as well as a senior director of engineering from Anywhere. And on June 10th, we're inviting a head of insights from Carta, who will be presenting a lot about fundraising and founder ownership of startups, as well as Vice President Millie Wang from 65 Equity Ventures to tell us a lot about fundraising and investments and things like that. The last page before we jump into the content. Right now, we're doing a lot of campaign for our engineer recruiting services. If you go onto our website right now and book a demo, we'll be offering a heavy discount, which equates to around 400 engineering hours. So please feel free to leverage that if you're interested in getting some development stuff done. That goes to my LinkedIn, so feel free to add me now or later. But without further ado, would love to introduce Stephen Ho, Vice President CEO of American Patent Agency. Please, everyone, if you could give a round of applause to Stephen.
Thanks. Oh. Oh, hold on for a second.
Just a few minutes.
Yep, sorry about this. Yeah.
Just takes a couple of seconds.
Yep. Okay, why does it look like this? Let's see what happens. Hold on.
Yeah. I think you just have to swap.
Okay. Yep. Yeah, what's the command for swapping?
Whoops. Do you just want to close it and then,
Yeah.
Or, sorry, close the
Yeah.
window.
Oh. Oh, you mean, okay. Yeah,
The
let's try that.
presentation mode.
Okay, yeah, let's do that. Let's see what happens. Yeah, let's pull this out.
Yeah.
Okay. Okay, let's put it back in.
Back in. And if you go to presentation mode, that should fix it.
There we go. Yep, perfect.
All right.
Okay, thank you. All right, thank you very much, Tom. So, welcome everyone. So just as a quick show of hands, how many of you have experience with patents, either as an inventor or someone considering filing? Okay, so among those, have you filed a patent application? Not necessarily received an actual patent yet, but at least filed. Okay. How many of you have actually been sued for patent infringement before? Or accused of patent infringement, or at least willing to admit that you have? Okay. All right. Okay. Just wanted to get a sense for everyone's experience here. So, of course, patent law is one of the areas of law and entrepreneurship that a lot of people ask about. And especially in the age of AI now, there's so many interesting questions. And today I'll be focusing on one particular issue, which is what happens when inventors use AI within the invention process, right? So this is just our firm's standard disclaimer about this particular presentation, right? This is strictly of an educational nature. So please don't go out there and actually rely on what I talk about today and then accuse me later of malpractice or anything like that. Okay. So I'll just give you some data points here to showcase how important AI is right now. So if you just look at how many patent applications and patents in recent years have AI in them to some degree, right? So this is really just about the subject matter of the invention itself. This is not necessarily people using AI to invent things in other fields. It's relatively strong, right? 190,000 AI patents are granted worldwide between 2000 and 2022. And obviously, there's a very strong exponential curve there. And no surprise here, China and the United States are far and away the leaders in these areas. So here I have a graph where I just listed the number of patent families granted to various inventors in different countries. And of course, you can see how the numbers are extremely strong. So this is an area that would just continue to grow. So in this slide, I just wanted to give you a broader roadmap before I jump to a very specific part of this. But this is just some areas in which many people in my field today are talking about how AI is affecting patents, right? So what happens when people use AI as part of invention? That's probably what a lot of you are doing. AI as a tool to use in aid in the invention process, and AI as an inventor, right? That's the subject of my talk today. A more interesting one is what happens when AI actually begins to be able to own something, right? There is some sort of legal personality that AI has. A lot of people talk about, does AI, can you sue an AI, right? Not necessarily the company that owns that AI, but suing the AI itself, or holding AI legally responsible for something. And then more on the technical aspect of patent law is what happens when AI changes the person having ordinary skill in the art standard. So one of the issues in patents is that in order to get a patent on your invention not only has to be novel, but also has to be non-obvious, right? But then the question is, what do you mean by non-obvious, right? Whose standard are you talking to? Is it Joe Schmo on the street? Well, no. In patent law, your invention has to be non-obvious to someone, a person having ordinary skill in the art, right? So if you invent something in mechanical engineering, it has to be non-obvious to a skilled mechanical engineer. But then what happens if everybody in your field now has access to AI? Now anything can become relatively obvious, right, in view of AI. So this is something that we are discussing about, whether or not the law should be updated to take that into account. The next few is also stuff that are more pertinent to what I do on a day-to-day basis, which is AI is a patent drafter, right? We all use ChatGPT and all these other tools like Perplexity and so on. And our company actually invests in companies that use AI as part of legal tech, right? For example, patent drafting. AI as a generative prior art. My intern and I recently published an article talking about that issue. AI as prior art search and examination, and then finally AI as an infringer, right? Like everyone's talking about agentic AI right now, right? Like what happens if you as a company, you build an AI, and then that AI infringes on other people's patents, and then you get sued for patent infringement? Can you absolve yourself of responsibility by saying, "Oh, I didn't direct, my company to do this. My AI did it"? Well, is that a good enough defense, right? So these are all very interesting questions that will be explored. So today, I'm going to jump into only a very specific part of this, which is what happens when inventors use AI as part of the invention and conception process, right? And fortunately, just in the past year and a half or so, patent offices around the world, including the United States, have issued official guidance on these issues. And then that's exactly what I'm going to jump into to explain what that is. So before we jump into AI specifically, let's talk about just traditionally, what is inventorship, right? And frequently I give this talk to people in academic settings, right? People who are graduate students and postdocs. And one of the most frequent questions or complaints that I get is, I was an author on that Science or Nature paper that my group published, but they left me out as a co-inventor on the patent application, right? Why is that? Are you trying to screw me over, right? And the question I want to answer about that is it really depends, because authorship on the paper and inventorship on a patent are actually judged by different standards, okay? So what is the standard for patents? Which is this. So to be counted as an inventor on a patent or patent application, the person must have contributed to the conception of the claimed invention, right? And then there's actually a legal definition about what conception is. The formation in the inventor's mind of a definite and permanent idea of the invention, including every feature of the subject matter sought to be patented. And you can already see how this could create some issues when you're trying to extend this into AI, right? Because it already says in the law, inventor's mind. Does an AI have a mind, right? That's a debatable philosophical and cognitive science sort of question. And that's something that people have to sort out later. What about joint inventors? And this is actually quite important because nowadays you have a lot of scientists and engineers who are obviously collaborating with other scientists and engineers, but then they're also using AI as perhaps another party that you can consider yourself collaborating with the AI, right? So the current rule now is that as long as you contributed to at least one feature of one claim on the patent application, you are counted as a co-inventor, right? No matter how important or small that particular contribution is. So when you see a bunch of people's names on the patent application, legally they're all treated equally, right? Even if their actual contributions under the hood might have been very unbalanced. So then the question is, if an inventor or a group of human inventors used AI as part of the invention process, should they credit the AI if the AI came up with some of these ideas, right? And I pulled these headlines from a few years ago when I started presenting on these topics. So these already seem a little bit out of date now, right? About whether or not, what are some of the legal issues that come up with this. And many of you have maybe heard about this particular case, right? This is actually one of the seminal cases about AI inventorship. And I'll dive more into this in the next few slides that's going on around the world. It's actually concerted worldwide effort that this particular inventor and his lawyers are doing to try to get his AI recognized as an inventor. So I'll talk about how that case is going. So this is the case. So let's start how it goes in the United States. So this is a physicist, Dr. Stephen Thaler. So he created a series of neural networks that he called DABUS. Name's not super important, but the idea is that DABUS is designed specifically to invent, right? So it actually creates patentable ideas. And what the scientist did is that he filed patent applications listing the AI as the sole inventor, right? So that's what he did. So he listed his own artificial intelligence system as the sole inventor, but he listed himself as the applicant, right? Because obviously the AI can't talk to the patent office, so he is representing the AI in that sense. And the patent office rejected it. They said that you have to list a human being. He went back and forth with the patent office. He eventually sued the patent office in US federal court and went all the way up to the federal circuit. So that's the Court of Appeals for the Federal Circuit. That's the federal appellate court in the United States that oversees all patent-related cases after it goes through the district court. And the federal circuit, they rejected his argument, right? And they agreed with the patent office. They said that inventors must be human beings, right? That's what the federal circuit said. And the United States Supreme Court refused to hear the case. So that is where the law stands right now in the United States, right? That only human beings can be listed as inventors of US patents. And recently, just February of last year, the United States Patent and Trademark Office, the USPTO, they issued official guidance, and this is one of the things I'm going to walk you guys through, on implementing that decision. So it doesn't mean that you cannot use AI at all. So there's a lot of gray area about what this means, right? Because whenever the courts make a decision, they only decide just enough to decide the current case, right? They don't necessarily try to go out of their way and create this whole new policy, right? At least they're not supposed to. But then it's up to other agencies, in this case, the United States Patent and Trademark Office, to implement some sort of policy that is in line with the court's reasoning that then provides some guidance for inventors and entrepreneurs and investors so that we know what is going to happen. So let's talk about I'm going to summarize the state of the law right now around the world. So most people in the patent world are interested in what's called the so-called IP5. So the IP5 are the 5 largest patent jurisdictions around the world. So we have the People's Republic of China, the European Patent Office, Japan, South Korea, and the United States. And all 5 have agreed to disallow artificial intelligence from being considered an inventor or a co-inventor of a patent application. So that is consistent across all the IP5 jurisdictions. Australia is kind of interesting. They actually briefly recognized DABUS as an inventor, but then the decision was overturned in a higher court later on. And South Africa is the only jurisdiction right now in the world that has recognized DABUS, the artificial intelligence, as an inventor. So like I said, this is the sort of the seminal case. This single inventor and his attorneys have filed lawsuits worldwide, really just to kind of be trailblazers in this field, right? They weren't necessarily expecting to win, but now they become quite famous in this area. So the question I want you to think about is, regardless of what the law says, do you think it makes sense or not, right? Because most people right now are using AI as a research tool, but we've all been pretty impressed with the pace of AI advancement, right? Just in the past couple years alone. And it's only a matter of time before AI can do things that are equal to the most talented humans when it comes to this stuff. And the question is, does it make sense to allow AI to be considered an inventor to that, right? And whether you think it's fair or not, I think it's important to think about what are some of the policy reasons why we have patents in the first place. So I listed some of them here, right? Because one of them is incentives, right? Why do humans want to get patents? Because you know that by investing all this time and R&D into something, if you get something that's patentable, then you can potentially make a lot of money out of it, right? And if you're investing a lot of different projects, then that hopefully at least some of them will succeed, right? That's the idea of investment. But is AI really motivated the same way, right? It's very, very hard to say. And then even if an AI does get an invention, who actually owns the patent? Is it the person who owns that AI, or is it the person or entity that trained the AI, right? A lot of unanswered questions there. And a real aspect of this, and this is also something I'll get into, which is what about AI innovating in other fields, right? Not just in computer science itself. And we've all seen how fast, I know some of you are involved in this, right? I talked to a few of you earlier before we started about the use of AI in things like drug discovery, right? Chemistry, and biotech and so on. And in fact, this was a major part of last year's Nobel Prize in Chemistry, right? It was awarded to 3 researchers, 2 of them who were at Google DeepMind, which created AlphaFold, an AI model that predicts protein structures, right? And this is a really fast-growing field right now, and it's accelerating biotech innovation much faster than any other development before. So of course, people are filing a large number of patents in this field. It's very important to understand whether or not the AI that they develop for this negates their own, inventorship over the kinds of inventions that come out of this. Right? We can skip this slide in the interest of time, but I just want to mention in case some of you are interested. And this is more about drafting claims. So if you used an AI that then discovered drugs, for example, how should you draft the claims? Should you try to get a patent on the AI itself, or should you try to get a patent on the drugs that the AI created? Ideally, if you have the money, you should try to do both, right? But if you can only choose one, then that's something that you should think about, right? So there's a lot of strategy involved in how deep you want to go in terms of your patent depth. The other related issue to inventorship is ownership, right? A lot of people get confused by this. By default, when you invent something, and you're the inventor on this particular invention and patent application, you are also the owner, right? But for most people, you're working at a company, and then you probably have a clause in your employment contract where anything that you invent is automatically being assigned to be owned by your employer, right? That's typical. And inventorship can never change, right? But then ownership can. So your employer gets the patent, but then suppose your employer decides to sell the patent to someone else and so on and so forth, right? A more concrete example would be something like art or architecture or anything copyrightable as well. If I design a house, say I'm an architect, I design a house, my name will forever be associated as the architect of this house, even though I sold it or even built it for somebody else, right? So someone else is the owner, but I am the architect. And then that owner can later sell that to somebody else, right? But of course, I can't sell the fact that I was the architect of this house to anyone else. That part is permanently attached to me, right? So right now, inventorship can only be human beings, right? Natural human beings. But ownership can be non-human entities. For example, companies are the most common ones. And the question is, should we allow AI at some point to be an entity as well? And would that permit some sort of AI ownership of patents? So that's an open question right now. And even more generally is what happens when AI creates other forms of IP, right? So we typically think about copyrights, patents, trade secrets, and trademarks. Just in the past year alone, there's a lot of chatter out there in the legal industry about copyrightable material, right? Generative AI. What happens when AI creates movies, music, and so on and so forth that are trained on other things before? Now you have people getting sued for copyright infringement, right? People are scraping data from the New York Times and all this other stuff, right? How many of you have read about that kind of thing? About the copyright issues with generative AI? Yeah, it's a major issue right now. And at some point, I'd love to give a presentation about that because a lot of people are following that. And I wanted to showcase one of the early cases in this. So this is back in 2011, right, 2011, about this. Haven't even heard about this, the so-called monkey selfie case. Okay, so this is a really fascinating situation that happened. So back in 2011, a British photographer, David Slater, he was in Indonesia, right, a professional photographer. And he had set up his camera, right, to take nature shots. And a macaque monkey that they later named Naruto, he swiped Slater's camera and snapped a few selfies, right? So this is important. The monkey actually grabbed the camera and pressed the button. So technically, the monkey took the selfies, right? And then Slater, he later published a book that includes the monkey selfies. And then PETA, the People for the Ethical Treatment of Animals, they filed a US federal lawsuit claiming that Naruto's copyright of the images had been violated. Okay, so they're suing on behalf of the monkey. All right, so let's see what happens. So the conclusion at the end of the day is that the court said Naruto has no standing to sue because he's not a person, right? So they do not recognize animals or non-human animals as being able to hold copyright, okay? But then they said, guess what? So they kind of split the difference. They said the Slater doesn't own the photographs because he didn't take them, right? He just put the camera there, but he wasn't the one who actually pressed the button to take the photos. So you, human photographer, you do not own the copyright because you didn't actually take the photos. But you, monkey, you don't own the copyright either because you're not a human being. So you see how that works? So then no one owns the copyright over this. So that was the conclusion of this federal case. And in sort of a, they kind of met halfway, and then Slater decided to donate 25% of the revenues of his book and the images themselves to, nature preservation in Indonesia. So it's kind of a nice conclusion. And right now, this is sort of the base case that a lot of people are looking at in terms of what happens when people use AI to generate things as well. Right? There's a lot of directives out there, and it's easy to get lost if you try to look it up, and I kind of summarized it here for you. So this is looking at the IP5 jurisdictions around the world, right? The 5 largest patent jurisdictions, about how they have thought about the issues with artificial intelligence and patent law, and directing people about how they should file for patents in that area. And the one that I want to talk about is the one highlighted in the middle, February 2024, the US Patent and Trademark Office Inventorship Guidance for AI-Assisted Inventions. So let's talk about that. And the most important thing is what they said here, is that, it's this last part. While AI-assisted inventions are not categorically unpatentable, the inventorship analysis should focus on human contributions, right? Because this goes back to the whole incentive aspect of it. Because AI is not going to be incentivized if you give them a ton of money, right? But then humans, of course, are. And we want to reward human ingenuity. A lot of it is kind of technical, like it's more interesting to patent attorneys and other people in the legal field about things like this later stuff. But the parts that I do want to talk about, of course, is naming the inventors, right? And how do you determine whether or not your invention has sufficient human input? So I'm just going to get into. So, as expected, the USPTO guidance, they affirmed the Thaler decision, right? The guy who tried to get his AI listed as an inventor. And of course, this guidance was issued as a response to that, right? So of course, they have to follow what the court said. So they reiterated what the court said. Only a natural person can be an inventor, so therefore AI cannot be. And analysis now becomes, did a natural person significantly contribute to the invention? Okay. And what they did was, they looked at past cases, right? This is what courts often do, courts and federal agencies, on related issues. And they try to extrapolate the reasoning. So they looked at other cases that involved multiple human beings to see what does it mean when you have multiple people who claim to have co-invented something. How do you know whether or not someone should really count as a co-inventor or not? So they used that analysis, and then they extended that to artificial intelligence. So there's this case back in 1998 called Panu v. EOLab, right, for determining joint inventorship. And then they looked at some of the key principles from that. And this is what they said. So first of all, an inventor must contribute in some significant manner to the conception or reduction to practice of the invention. They must make a contribution that's not insignificant in quality when that contribution is measured against the dimension of the full invention. And they must do more than merely explain well-known concepts or the current state of the art. So you're probably looking at that as like, well, what does this mean? Right? That sounds pretty obvious, right? So let's dive into what the USPTO thought about this. So what they did was the USPTO came up with a set of 5 non-exhaustive guiding principles for the analysis. First, they said that AI assistance is allowed, right? So it's not like as soon as you start using AI, then oops, you cannot get a patent on this because you're cheating in some way, right? They're not like some universities now, because I think that's in flux too, right? About a lot of professors saying, oh, you may use AI, and others say you can't. And the ones who say you can, there's a lot of policies attached to it, right? Well, this is now the USPTO version of that, right? About what's the permissible use of AI when you're inventing something. So first of all, yes, you are allowed to use AI when you're inventing something. But recognizing a problem is insufficient, right? So you cannot just think of a problem and then prompt your AI to solve the problem and then try to claim yourself as the inventor on that solution, right? See, that makes sense. I think everyone agrees to that, right? You can't be like, oh yeah, I'd love to find a material with this property, right? And then you just tell your AI, it creates it, and then you try to get a patent on it, right? So that's not fair. But then there's a lot of caveats attached to that. One of them is this. However, a significant contribution can be shown by the way the person constructs the prompt in view of a specific problem to elicit a particular solution from the AI system. And what a lot of people think they mean by this is suppose that you do pose a problem to your prompt, to your AI system. They give you some vague solution or maybe one that doesn't work very well. And you kind of go back and forth with some very clever prompt engineering. So you are, in some sense, using your own expertise in this field because you know exactly what questions to ask. And it is a form of experimentation if you think about that, right? So I think the Patent Office kind of opened the door to that sort of clever prompt engineering that would permit a human prompt engineer to be an inventor on a patent that was generated in this way, right? Okay, the next principle. Reduction to practice is insufficient. So what is reduction to practice? There's two forms. One way of reducing something to practice is to actually build a working prototype, right? So conception is you simply have the idea in your head, whereas reduction to practice means that you either have a working prototype or you have actually drafted a sufficiently detailed patent application, right? Okay. So what do I mean by this? Reducing an invention to practice alone is not a significant contribution that rises to the level of inventorship, right? So that's merely a technician, right? So if I just, even without AI, if I invent something and then I tell my technician to build it, it doesn't mean that that technician now becomes an inventor, right? He just followed my instructions. But if my instructions were vague and then my technician had to figure out a lot of details on his own, then now he might actually rise to the level of becoming an inventor on whatever details that he had to figure out, right? And the same concept is true here as well, which is a natural person who merely recognizes and appreciates the output of an AI system is not necessarily an inventor, right? So if your AI gives you this amazing invention, you're like, oh, this is cool, and then you build it according to what your AI said and it works, that does not make you an inventor. But if the AI gave you something that was relatively vague, and then you had to tinker around with it to figure a lot of details out, now you might be considered an inventor, right, as a human being. So you see how they really were quite thoughtful about this, and they really tried to stick with what the law said about other cases involving multiple humans and trying to tease out how would we extend these ideas if we include artificial intelligence in the conception process. All right, they added some details here. You can look up the guidance yourself if you want to jump more into it. But some of these are actually quite interesting, which is the middle one here. However, a person who takes the output of an AI system and makes a significant contribution to the output to create an invention may be a proper inventor, right? And that's what I was talking about before, right? So you're allowed to use AI as part of the process, but then you as the human have to add something significant to it as well. Right? That's not hard to do if you're an expert in that area and the AI gives you something that is workable. This is the one that a lot of people are still confused about what exactly this means. It's going to take some time for us to see more cases to see what they mean by this, which is developing an essential building block may be sufficient, right? Because when you're inventing something, it could be a very complicated invention. It may have a lot of different steps for making and using it. If there's one particular aspect that is essential, and you as the human being were the one who conceived of it, then that might actually be sufficient, right, for you to do that. And then the last one here is very important. This is something that should be considered obvious, but it's something that the USPTO wanted to emphasize, which is ownership or oversight of an AI system is insufficient. So this is what we call intellectual domination, right? So just because you own the AI doesn't mean that you become an inventor on everything that that AI generates, right? If that makes sense. And the same thing is true for copyright as well, right? If I create this amazing AI that writes great music, I should not be listed, right, as the composer of that music just because I own that AI system. So the USPTO, they were very helpful in this, because this is all very theoretical, right? But they actually published two sets of hypothetical examples to help inventors understand this. I encourage you to look this up. So if you actually look up, USPTO inventorship guidance, and then like transaxle or something, you'll find this very easily. So the first set of hypos they provided is a transaxle for a remote control car, and they actually had 5 different combinations of scenarios about two inventors who use AI as part of the process. And then they said, oh, if they did it this way, then AI doesn't, this is not enough. The AI did too much work, basically. So these human beings should not be counted as inventors at all. No one gets a patent. Whereas in these 2 other scenarios, number 3 and 4, the humans are proper inventors, right? So I'm going to talk about number 3 a little bit, because I think this is going to be the most common scenario that inventors find themselves in. So here's the scenario. Engineers Ruth and Morgan, I'll just call them R and M from now on, they're tasked with designing a transaxle for a remote control car. They use a publicly available AI, Puerto 5, that receives natural language prompts as input and generates text and images as output. So they start by prompting Puerto 5. Create an original design for a transaxle for a model car, including a schematic and description for the transaxle. Right, we just made the mechanical engineers work so much easier, right, by prompting it this way. They further prompt Puerto 5 to provide alternative transaxle designs, and of course it outputs some designs in which the casing elements could be separable along a horizontal plane. R and M decide to build this design having a horizontal separation. And then the prompt goes on and on, and they realize there's issues with this, so they have to put in their own modifications on what the AI told them to do. And then they conducted experiments on that, and they learned from that feedback, and so on and so forth. And the USPTO says that based on the additional conceptual work that the human beings had to do, this is okay. These 2 human beings count as a co-inventor, even if the AI did that initial draft of the invention. Does that make sense? So it's kind of good, right? Because I think a lot of you are probably in this sort of scenario. So I think this is the most common one. So then they walk through the Panu analysis about what this is, and of course, the 2 human beings are indeed proper inventors. There's a second scenario they offered. This one's a lot more complicated, so I'm not going to get into this at all, but this is more on the drug discovery side. This is also the kind of scenario that a lot of you might be in if you're in the biotech industry, which is you have a lot of different parties, right? You have people overseeing research. You have a postdoc who's performing lab work. They consult an AI expert who builds an AI model trained for that particular task. And then depending on who is involved with what and what is the extent of everyone's contribution, that could determine who counts as the co-inventor on this. So the key takeaways, right, from this inventorship guidance: AI cannot be the sole inventor or even a co-inventor, right, on a US patent application. The use of AI in the conception or reduction of practice of invention does not negate human inventorship. So it's okay for a human inventor to use AI. But a natural person using AI is an inventor if the natural person makes a significant contribution, right, to the invention, as we talked about. Okay. And this is determined on a claim-by-claim basis. So the USPTO might complain about some of your claims, right, on this front, but then other ones might be okay. And one thing that's important to note is this last portion, which is the guidance did not state any requirement or duty to disclose to the patent office that the inventor used AI as part of the invention process, right? So if you do use AI as part of your invention in terms of how you created this, you actually do not need to disclose to the USPTO that that was the case. But of course, if your invention requires the use of AI to do something, then of course you have to. But if not, then it's not a requirement. And this is actually in contrast to the US Copyright Office that also issued a guidance around the same time, which does require the disclosure of AI tools used in the generation of creative works. So this is quite interesting that there is that distinction there. I just listed some references here, not super important, but this is the one that I encourage you to look at. The USPTO actually has a whole website on anything related to AI inventions, including the guidance and of course anything in the future. So I encourage you to Google this up and to look at the ones that might be relevant for you. And then as my second to last slide, a little bit of self-promotion of our firm. So we have obviously thought about these issues a lot, and we published articles about this. So I have 2 recently published articles that dive into this further. The first one was published last year, and this is a summary of all the IP5 offices and what they say about anything related to AI inventions. And it's 12 months ago, right? Just May 15th of last year. So exactly a year ago. And it's already out of date, right? So this is something that we'll have to pay close attention to. And then the other article we just published last week about what happens when in the world of generative AI now. Like what happens if people use AI to then just generate a whole bunch of scientific articles online that serve as prior art against other people's inventions, right? How are we supposed to deal with that issue? So we have an article that talks about that. And then, I just want to close with some potentially interesting questions for you. Like, what happens when we actually reach AGI, right? Artificial general intelligence and singularity? Will we actually need a patent system anymore, right? If AI can invent anything that any human expert can, and how would that fundamentally change the purpose of human existence? So with that, I'll turn the floor back over to Qlay, and thank you for your attention.
Yep. Yeah, we'll do Q&A. I think we can do a little bit of Q&A.
Yep.
Can we do some Q&A? Okay, awesome.
Yeah.
We'd like to do a Q&A. I guess you first said. Let me give you a mic, actually.
Thank you. I have quite a few questions, but the answer will be simple yes or no. So before using AI for, not for invention, but for describing and generating claims, because I don't want to be busy with bureaucratic terminology and language, also in engineering terminology. So I kind of put in memories in ChatGPT that I hire you, so you are not part of invention. I hire you like a translator, like everything, so you are not part of my invention. That's what and the same with when I create text. I can ask ChatGPT to translate it properly. And also I ask ChatGPT that you are not part of copyright. You are just translator, I hire you. If AI can do something about that?
So that's a complicated question. Yeah, I think the safest answer is it depends, right? But if you're just using AI as like a query system to kind of be able to do further research or to gather information. Oh.
Even like a patent in China in Mandarin, I have no clue about Mandarin structure of patent, but I asked ChatGPT to put my invention in Mandarin department, Mandarin office of IP.
So are you saying that you're using AI to
Yes,
explain and translate?
I invent things, but I have no idea what structure, how they do it in China. And I also don't know Mandarin, but I asked ChatGPT to do it for me.
I think that's perfectly fine because you conceived of the invention. Yeah.
Yes, so Madrid protocol, does it follow the same thing that AI is not inventor?
Correct. That's correct.
Okay.
Yeah.
And if you use AI like brainstorming for like AI is devil advocate, is it does it give AI any rights for invention or for copyright?
So AI has would never be listed as a co-inventor, right? So if you are using AI for brainstorming, but then you are
invention for proper wording.
For what?
Proper wording.
Oh, okay.
Translation.
Yep. Yeah, that's perfectly fine. Yep.
And monkey selfie, by the way. I'm curious why this photographer didn't simply say that, yes, I say that monkey took the photo. It is my job. It was me.
I think he was just being honest, to be honest. I think he thought it was pretty cool that a monkey took a selfie, right?
Yes,
so,
for marketing.
Yeah.
And is OpenAI create special team for look what actually people create, what people invent with AI, then to sue them if they use AI as an inventor.
Oh.
Say that it's
I can't comment on that, so I don't know. If people invent something using AI, and then USPTO say no, it's AI invention, so you're not inventor. That's it. But then that's become public, right? Yep.
So nobody can invent the same thing.
Correct. That's correct.
So some devil engineer can do everything.
Exactly. That is correct.
So
Nobody.
How to go? If somebody do everything about that?
That's correct. So basically, so this is not even with AI, right? So if you submit a patent application on something, and it gets rejected for any reason, and you're unable to overcome that rejection, that patent application will be published. So not only does the entire world know about your invention, but you also do not have a patent on it, right? So in some sense, that's the worst of both worlds. That's right, and no one else can get a patent on it either, because now your published patent application serves as prior art against other people. So that means that anyone can freely practice this invention.
Thank you very much.
Thank you.
Awesome. Anybody else? I think you had one. Okay. Here you go.
What was the reason? First of all, thank you for presentation.
Great.
What was the reason for Professor Thaler to claim that AI invented?
Yeah, that's a good question. So along the same lines that you said, that professor could have just pretended that he invented it, right? Like he just used his AI to generate ideas, but then he just sweeps that under the rug, and then he himself just applies for the patent. In reality, without evidence to the contrary, no one probably would have disputed him on that, right? Because if you're just a guy in your garage and you claim to have invented something, no one is going to be like, wait a minute, did you really invent that? Or did you steal that from somebody else? Or did you use AI, right? Especially back then. His motivation, and this is publicly known, so it's not like I have some kind of secret information. His motivation was really just to be a trailblazer in this field. He wanted his AI to get recognized as a co-inventor. Because the inventions themselves, I didn't even talk about what they were. They weren't even that interesting, to be honest, right? So he thought it'd be cooler if he was the first creator of an AI that got recognized as an inventor than him being an inventor on these specific patent applications. And it worked. He became famous because of this.
In case of monkey, how does PTO decides what is human? Because the way the monkey did it, he was even smiling at the camera, right? How is it defined that something is human versus not?
Yeah, so according to US law and every other jurisdiction I'm aware of, any member of Homo sapiens would be considered human, and anything who's not would not be, right?
By the way, who press the button is employee, and person who behind the camera say how to speak or how to smile or not is an author of the
Right.
process. So monkey is employee.
Yeah, so it's arguable, yeah. Oh, so yeah.
So you talked about the invention being novel and non-obvious. So, like for an example of like in legal field, right? And you create a function calling agents to do something that a paralegal would do, like moving paper, creating different documents. Is that like what part of that is like? Is that not obvious? Because I mean, you're creating the AI agents, right? Not necessarily. It's kind of an obvious process.
Yep.
We all do it. Can you talk a little bit about that?
So let me try to make sure I understand what you're talking about. So are you saying are you trying to get a patent on an AI paralegal?
That would replace the job of a paralegal.
Okay,
theoretically.
yeah. So that on its own would be considered obvious, right? But if you created some kind of AI architecture or model or something like that, or some specific training to make your AI paralegal more successful than others, then that could be considered something patentable. In fact, the vast majority of AI inventions, and in my firm, most of our patents right now are in applied AI, right? And that's exactly how we're successful in getting those issued, is that we're emphasizing what is the unique AI architecture or training process that other people in your field would, and it's not like they would not have thought of it, but then they would have had to tinker a lot or fine tune a lot to figure it out. Yep, exactly.
Awesome. Anybody? Oh, there you
Hey there. I guess one question is, should you be logging then your interactions with the AI? So let's say your patent does get filed because you didn't have to disclose that you used an AI, so that it gets granted. But then someone comes after that patent and then they say, I think you just used an AI. Should you be logging this kind of and having that evidence just in case?
That's a good question. I think the safe answer would be to say yes, right? And that's equivalent to when you have multiple people who collaborate. It's good to log who contributed what, because that could always be disputed or people forget details years later, right? So, oh yeah, how come you left me out as a co-inventor? I was totally part of that conversation. They're like, well, no, you only jumped in, in meeting number 5, and then, So it's good to have any kind of memorialization of how you use the AI, what prompts did you use, what outputs were given, what did you modify so that you contributed further to what the AI did, especially if you think there might be questions about whether or not you are truly an inventor of this.
Just one follow-up on this question. So are people actually trying to patent prompts? I mean, because it seems like you could go out about building this paralegal system just by prompting. I mean, are people, and similarly for weights of the trained model, I'm just kind of curious how things like that are handled.
Yeah. So as far as I know, you cannot get a patent on prompts or a set of prompts, right? Because that's not an invention. Technically, you could get a copyright on that if you wanted to, right? But what would be interesting is if someone created like a AI agent system that automatically prompts things a certain way, that could be something that someone might be considered patentable, especially if the way that you do this is considered non-obvious. Right?
Awesome. Anybody else have any burning questions? Okay. Cool. Well, thank you so much, Stephen. If everyone could give a round of applause to Stephen.
Great. Thank you.
All right. Oh. Okay.
If you brainstorm with ChatGPT, the best title for your article or for your brand, will the AI will be part of the spending?
Oh, no one cares about the title, so that's okay. Yeah.
All right. Cool. Thank you,
Great.
Stephen.
All right. Thank you very much. Thank you all for coming.
Thanks, Stephen. Much appreciated.
Great. Thank you.
All right. Yeah, feel free to, I think there's a lot of pizzas left. Feel free to hang out here and network a little bit. We have to kick everybody out by 3 p.m., but until then, you're all good. Thanks. All right.
Great.
That was awesome. Thank you.
Great. Thank you.
That was an interesting session.
Yeah. Yeah.